condone it by allowing it to pass without ever questioning it.
Thank you very much. I'm giving the last opportunity to because Honorable Boy.
No, but
let us speak.
Thank you so much, Honorable Chair. Majority Chief Whip said something that Speaker would be disrespecting the Speaker if we went ahead. I'm quoting you. And I'd say that Speaker is a legal man. He'll be very happy if we pointed out to him if he had gone wrong. The nominee, I mean, just by seeing her, I really like her. But that shouldn't be the yardstick. Let's do what is right. We are the gatekeepers. If, like the issue Honorable Ayariga raised, we've been doing the wrong thing and we do it right, there's nothing wrong with it. So I think I agree with him. Thank you.
Thank you very much. I think we should really end this.
Honorable Gift Chief, please.
Thank you very much, Madam Chair. I would like to get some education here. Maybe the ordinary English that we've been taught. The error to the ordinary English students, to the ordinary English students students, if you say at least 9 students, if you say at least 9, and you don't bring at most, it means you should make sure that at any point you don't have less than 9. But depending on the situations around the cases that you have, you may jack it up. So whether you take it to Supreme Court or you take it to preliminary, it is still the white light. So I appeal that, yes, we've been educated. Yes, the English students among us, we were not given at most, we were given at least. So that we manage this today. And then going forward, we see how well we could bring the highest caveat so that it wouldn't be like if whoever is in chair wants to appoint 300 Supreme Court judges, it becomes on and on and on, but we get to some. We need to start from somewhere. But I want to appeal that to start from today, it's a bit too late as of now, so let's get it done. And then we, as we are educated, we do the needful. Thank you very much.
Okay, thank you. I think the honorable member didn't get it right, if I may so say. It's not so much about the limit or the list. It's about how the discretionary power is exercised. That is the point the honorable member Ayariga said, and that is what the majority of us here have supported. So it is not about the grammar of it, but it is about how the power is exercised, that we've been doing the wrong things. And if the Constitution says that if you are doing the wrong thing and your attention is drawn to it, you have the room enough to go back and correct yourself and work within the Constitution. So that is where we are heading towards. And I also, Madam Chair, I also want to say that it's unfortunate that our deputy, the chief whip is okay, so he gets in now. Because the cameras are here and the public is having privy to what we are discussing here, it will not be fair to place on record, as you did, that the previous engagements we've not raised issues of concerns like the one that Honorable Ayariga raised. I am not so much aware, maybe it happened on my blind side as a member, of the engagements on this particular appointment or the vetting. If maybe it was a matter of leadership discussion, that is fine, but it will not be fair to say that we've had several engagements and these issues have not come up. I think that should be corrected if that is not the case. Thank you.
Chair, again, I hear my name loud and clear. I think I saw, Madam Chair, I mentioned her name. Madam,
The floor is given to you.
Okay, so maybe I should simplify what I said. And if I meant to convey any misgivings, forgive me. What I meant to say is that fundamentally, is there any provision in this constitution that has been flouted? Fundamental question. And the answer is no. No? So if you are claiming that there is any specific proviso in this constitution that has been flouted, point it out to us. Even if it is the case, if you are even able to do that, that will reflect in our report. That will reflect in our report. Nothing should stop us from proceeding to consider the nominees. And at this juncture, without adding more, Madam Chair, I invite you, if you allow me to be the first person to start my questions. I have my questions ready so that I can start. Yes.
Madam Chairperson, Madam Chairperson,
Honorable Ayariga.
Yes, I intend to move a motion.
Pardon?
I intend to move a motion.
No, Honorable Ayariga, I haven't given you the floor. Thank you very much. I think we have had a fair discussion on these issues, and it's now with the leadership.
Yes.
So I'm going to ask Honorable Boa.
Thank you, Chair. Thank you very much. I simply want to make this point that what we are discussing here has precedent, and it's very, very important. And I want this committee to understand a history of how at 919 the petroleum law was passed. I remember that we had brought the bill to the Energy Committee. Honorable Jogati had raised very fundamental issues relating to the Constitution, which is always our guide. And he drew our attention at the time that we needed to make sure that there was a regulator because that resource is a natural resource, and the Constitution requires that we should have a regulator. That is how we came back. We suspended the passage of that law, went back to bring the Petroleum Commission Act, passed the Petroleum Commission Act before we went to pass at 919. Now the point that has been raised here is very important. The Honorable Ayariga has drawn our attention to our guide, which is the Constitution. We are guided by the Constitution in everything we do. And the point he's made is that there's a limit, but there's no upper limit. And because of that, there has been this discretionary power being used by the president, and we have an opportunity to address that. I think this point has been made. But for this committee to take this very important point, which really is at the heart of the Constitution, back to the plenary and the Speaker, is something the Speaker and the plenary will be very happy with. The Speaker will not be unhappy at all. It is also important we know that this appointment committee has the authority to address this issue, and no other committee can. It is this appointment committee that must go to the House with this very important lacuna to get the House to address it. And so this point that has been, you agree? So the point that has been brought by the learned Honorable Ayariga must not be something we wash away. This committee must make a decisive decision. A decisive decision. Whether to go forward or not. And so, Chair, it is in your hand. We need to make that decision. And so I think clearly...
Before then, Madam Chair, the letter from the President, appointment of justices of the Supreme Court. And I read the first two paragraphs, and you understand why there's the need for us to pay attention to what Honorable Ayariga is saying. It says, I hope this finds you in good health and spirits. As a result of pending and projected vacancies on the Supreme Court, occasioned by the retirement of Mr. Justice Ni Ashikote on 2nd October 2023, and pending retirement of Justice Mariama Owusu on the 18th November 2024. Can we please, 2024, respectively. The Judicial Council advised me on 24th May 2024 by letter under the hand of its chairperson, Chief Justice Gertrude Tokono, of its nominations for my appointment to the court of their replacement in accordance with Article 114(2) of the Constitution of the Republic. Then it goes on in paragraph 2 to say that in order to achieve the full current complement of the justices of the court of the next legal year, I have decided to appoint the Supreme Court as advised by so and so. My question is, and Madam Chairperson, my question here is, it says, in order to achieve the full current complement of the justices of the court for the next legal year, who established the full complement? And what is the full complement? The Constitution placed a minimum number, 10, Chief Justice and 9 others. Now we are talking of the full complement. And the letter in the second paragraph says that in order to achieve the full current complement of the justices of the court for the next legal year. Now, what is the complement? Who established that? Is it a matter of the Constitution? Is it only to the president to appoint to establish the complement, or is it for parliament or a law to establish that complement? And that is why the argument coming from Honorable Mama Yarega cannot be washed away. They are critical questions. Look, I believe in continuous improvement of our governance. You can't get it right from day one. But let it be that at any point in time, we sitting here as elected representative of the people, we must add value to our democracy every single day. Now we are seized with the opportunity to add value to our democracy, to make a determination that all presidents probably may have eluded them. And someone has pointed us that something is wrong. I think it's only right that we listen to him, take an action, and then do this. Madam, on the basis of that, I move that this motion coming from Honorable Ayariga be taken, and that we should vote on that matter. Thank you.
I think, first of all, Madam Chair, I think my respected leader should get his facts right.
I second the motion.
Respect to him. The Honorable Ayariga didn't move any motion. That we don't have any motion here. What he said, please, when you speak, you should listen to us too. He says, and he paraphrased, amongst other things, says that he wants this to be captured in the report of the appointment committee. The chairperson has not entertained any report. He has not entertained any report. So if it is the case that I want to come by a proper motion for us to take a decision on this, then we should take a decision. But even that would be wrong. Madam Chair, that would be wrong. Parliament cannot be stopped from performing its statutory duties. And one of our statutory duties, as an extension of Parliament, an appointment committee to consider nomination from His Excellency the President. What are we doing? We are only to vet and to report to plenary for a decision to be taken. We are not determining whether we are going to take a matter under certificate of agency, which will be determined by a committee. No. This is vetting. Madam Chair, I invite you. I am ready for us to start.
Thank you very much. Thank you very much. Honorable members, I think I've given a fair chance to each member to make his or her point. Here we are. This is a constitutional issue being raised out here. It is the Supreme Court that determines the interpretation. Honorable member, please give me the opportunity to also speak, because I've given you adequate time to do that.
He spoke for 30 minutes.
Yes. So, you have made your point. Who interprets the constitutional imperative of this particular thing? So, as said by Honorable Ayariga, it should be captured in our report and we take it at plenary. And I'd also want to move that we move ahead, because you see, when the letter came, Mr. Speaker had a look at it, came to the floor of Parliament, and then read the letter to the hearing of members present. And Mr. Speaker referred it to this committee to proceed and vet our nominees. At this juncture, I think we have to just move on and do what is being required of us, the mandate that has been given to us, and we move ahead. We have an appropriate forum where we can address this issue. I think we have been given a referral, and our core mandate is to ensure that we go ahead and do what is needful. Thank you very much. And so I'm going to start. Yes.
I want to start. I'm ready to start.
No. With your indulgence, committees of Parliament have the right to organize their meetings in the ways according to with the standing orders. Mr. Speaker, Madam Chair, indeed, we have actually convened committee meetings and have taken decisions at those committees not to entertain the subject matter before the committee. So there's nothing wrong if Honorable Amayariga is making a request. Ask the minority, move a motion. So allow him move his motion. Yes.
The orders are clear. Order 267 says that only members of a committee may vote or move a motion at meetings of the committee. So I have raised an issue. You have allowed everybody to chew on the issue. And then I'm now saying on the basis of the deliberations that have taken place. And let me correct you if you have forgotten. I was sitting there when Speaker read the letter. And in referring the letter, these legal arguments that I'm raising, he raised them. Mr. Speaker drew attention to a long-standing debate as to whether or not we don't need a legislation to determine an upper ceiling. But said that he as Speaker cannot. But that he's referring it to us as a committee. And that we should go and decide what to do. So I move that we have raised the issue, we've debated. I move that we end proceedings and refer the matter back to plenary for consideration.
Honorable member,
I second.
Honorable member, I think that we are not being fair. No, I'm not going to allow it. But I'm going to. No, please. If you have, I have to give you the opportunity to also second it. But I'm also making my point. Okay. Yes, my point is that we have been given a mandate. We are going to proceed. Right. No. Because it's also not fair that you invite your nominees to come. Yes.
Let's deal with the motion. Then we can continue. Let's deal with the motion. Then we can continue.
No.
Ready to start. Madam,
my brother,
can I?
Chairman.
Yes, I can start.
Chair.
Honorable nominee.
Chief Whip, don't let the meeting. Don't let the meeting degenerate.
No, I'm not.
A colleague.
No, I'm not.
Hold on.
I'm seeking. So I'm seeking the chair's mandate. Can I proceed?
No.
Yes.
Chair. No.
Madam
Chair. Please be fair. Chair.
On your
a colleague
nomination by the president.
Chair. You want
and
to
let me find out from you.
Chair, please. A colleague using the standing orders by which you and I took an oath to protect moved a motion that this committee take a decision as to whether we want to continue. As a leader and the chair, all you need to do is you have no right to deny the branch aside. All you can do by law is to put it to a vote and wait for the decision. You have absolutely no powers sitting in that chair to decide that you brush it aside and order people to start asking questions. It does show me the standing orders which you are going to quote to set his motion aside. Quote it.
Likewise, if we are going to...
The chairperson has a mandate. The matter was raised, Madam.
Are you the chair?
Please.
Why do you keep interrupting the chair?
Please. When the matter was raised, please, with greatest respect, Honorable Lamte, I have not interrupted you. Well, Latte, well, I have not interrupted you. With respect, I have a great deal of respect. When the matter was raised, the minority leader says, let's allow views to be ventilated. In fact, let's be fair to the chair. She's been overly democratic on this matter. Everybody has spoken at length. And then she's ruling. No. You must respect. She can. The speaker, the chairperson can rule. And her ruling is that, no. Would you listen to me? Her ruling is
why should we listen to you?
It's a constitutional matter.
Why should we listen to you?
No, why shouldn't you?
When you don't want
it's
to
listen to It's a constitutional matter that has to be interpreted by the appropriate forum. We do not have the mandate. We do not have the mandate. She has ruled that we proceed, and they will prepare a report, and the dissenting views will be captured in the report. That is what it is. That's what it is.
There's nothing in the standing orders that can make her set aside.
I feel very bad about this.
By a colleague. Let her coast. There's nothing in our standing orders.
No.
What?
Again. Yes.
Okay.
Then we can move forward. Let's go and
yes,
listen
again, Madam Chair, if I may just conclude. Again, I think we engage.
Yeah. Madam, Madam. First, nobody is going to vote. The colleagues, honorable colleagues, Madam Chair.
So you're objecting.
Our work here, Madam Chair. Our work here, colleagues. We perform our functions using our standing orders. That is our guide, and that is what we use to perform our functions as members of Parliament. A colleague has brought an issue which he believes is quite germane and something, in his opinion, is unconstitutional, and it has generated a lot more concerns and debate. He believes that the vetting must end before this matter that he's raised be discussed and, where possible, put to a vote at the floor before we come back. Now, a motion has been moved by himself. I've seconded that motion. Madam Chair, you cannot and you do not have the power to put that motion aside and then go ahead. That there's nowhere in our standing order that equips you to do such a thing. You do not have that power. Secondly, this is a committee that you are more than us. The majority obviously outnumbers the minority. Why are you running away from vote? Why are you running away from voting? So what we can do here is to subject the motion to a proper vote. And when the vote, for example, whoever, if he loses the motion, then we can move forward. But until then, please don't let this meeting to degenerate. It is wrong. It is wrong. Let's put this to a vote. If he wins, fair enough. If he loses, fair enough. But until then, this vote will count.
Chair is because of the standing orders and the rules of the House. It's the same rule. Chair is because of the standing orders and the rules of the House. It's the same rule Honorable Ayariga invoked by calling for a vote. So, Madam Chair, a motion has been moved and seconded. The only thing you can do now is to put to a vote and look at the outcome, and then we proceed.
Right, thank you very much. Yes. I think, yes, this is, I have made a statement. That's the interpretation of the Constitution lies in the bosom of the Supreme Court. So, over here, I know we are masters of our own rule, but if you can quote which aspect of the Constitution that we have breached, then we will take it for the right interpretation. So I don't think that the motion here is, I think the motion is overruled. Thank you very much. So
Chairman, Chairperson, you've said something which is not accurate. No one here is asking for the committee to interpret that part of the Constitution. And I remind you that hold on. And I'm saying that on countless occasions we have been presented documents or information at committees, and committees take a decision. We shall not entertain this issue because of one thing or the other, or we are looking for extra information. It does not matter what the committee thinks. That is democracy. A motion has been moved and seconded. Madam Chair, you have absolutely no right to say that, as far as you are concerned, you are going to rubbish what our colleague have said and move on. Move on and to where?
Madam Chair.
Madam Chair, you do this. Madam Chair, you see, we are on telly. Do not make this meeting degenerate. You are a majority. Why are you afraid of voting? And if anybody tells you this vetting will take place by your bravado, it will not take place. Do the right thing and peace will be here. If you fail to do what is right according to our standing orders, I can guarantee you that chair will be very hot for you. I'm telling you. It will not. I'm not threatening.
No.
Because if you breach the law.
No.
Listen. Let me repeat. Let me repeat. Please. Madam Chair, listen to me. Listen to me. I said listen to me. Why don't you listen to me? Madam Chair.
No.
I said let me say it.
Please.
You said please let me listen to me. Madam Chair. You are the one in the chair. You have obligation. You have obligation to use the standing order to do the right thing. I am telling you, if you fail to do the right thing, it will degenerate. So protect the standing orders and the Constitution. Okay. Do the right thing.
Yeah, Madam Chair.
So who created that problem?
Yeah.
Please put off the.
I think this is the way forward.
Yes.
A motion has been moved and seconded. Let's bring finality to. You heard it. Let's bring finality to that motion. Then we can move on. Chair, it is simple. Read the standing orders.
Madam Chair,
we have to deal with that issue. Let's bring finality to the motion on the floor. Then we can move to the next issue. Madam. Yeah, it's very simple. Let's move.
Madam Chair, I want to remind the committee that we are vetting a nominee to the Supreme Court of Ghana. And it is very important that we don't mar this space. The reason is that the Supreme Court is a very, very important court. And we know that that is the highest court of the land. And because of that, it is very important that whatever we need to do procedurally to ensure that there is sanctity in the process, we do so. So I would beg that as the motion has been moved and seconded, if we can proceed on the motion, and if the motion loses, we just proceed. That way, we don't mar this whole process where a very highly reputed judge has been nominated to the Supreme Court of Ghana. It's so important that we protect the sanctity of the process through which she is confirmed. Thank you very much. Madam Chair, if you allow me, maybe this will be my final statement on this same matter. Don't forget, we got to a situation near to this before. And the leadership related and set a date for this vetting process. As far as I know, for the fleeting period I've been on this committee, anytime any side feels strongly about something, it is communicated ahead of time. This comes as a surprise. To be very honest, I'm not saying no, well, I'm not quoting standing orders. This comes as a surprise. You know, we are a house, regardless minority, but we are a house. So if we so decide that we want to vet a nominee, and we fix a date together, and we invite the nominee in, and then we start throwing, statements at each other, it's just not right. I feel ashamed because I thought that all T's have been crossed, all I's have been dotted. We are just coming to do the vetting. If the Honorable, with greatest respect to the Honorable Atuforsen, if this matter had been communicated to us, and you know how you and the leadership of this committee had always related to deal with these matters, where you feel strongly about something, you communicate it ahead of time. What she's saying is, without necessarily repeating the point, Honorable Ayariga has raised a very important matter. In our quiet life, we've all related on this matter. Okay, well, why is it that there's no upper ceiling on these appointments? We've all spoken to it, but the Constitution is silent on it. Who doesn't know this? Everybody knows this. That is why, in the wisdom of the Speaker, he referred it. Otherwise, the Speaker wouldn't have entertained the correspondence from the President. So please, I only want to appeal to members. Vetting the nominee does not make it conclusive. We still have to consider the report of this committee at plenary for a decision to be taken, either to adopt the report or not. No, Kwame, I beg you, in the name of God, please, I want to appeal to my colleagues, particularly the minority leader. Let's go ahead. All of us have spoken to how competent they are. In fact, the Honorable Ayariga has said that they attended similar schools and has spoken to how competent they are. We've all related to their CVs as competent people. It will be most...
all of us. Did I speak to you?
That's fine. It will be most unfair, colleagues, for us to say that we will not even listen to you. Let's listen to them, and then we can take the decision, and that decision will reflect in our report. When it gets to plenary, Honorable Atuforsen, I'm not done yet. I beg you. You see, Senior, you are a senior person. You know how I respect you. Anytime there is a matter that relates on patriotism, you have stood tall. At the final committee, when I was a member, I know you, and I can testify. Several occasions I've had the opportunity to speak to how patriotic you are as a citizen. It's not patronage. If there's patronage, if there's anybody to be patronage, it's you that will patronize you. I'd rather patronize you, not the leader. They say monkeys play by size. I'm not his size. He is up there. Yeah, I'm a whip. If I'll patronize anybody, it is you. So if it is the case that we should suspend and de-escalate, that's fine. I will support that. But you see, we have embarrassed the nominee. In a way, we have embarrassed the nominee, which is not appropriate. So, Madam Chair, let's suspend for 30 minutes, and then we can 10 minutes, and then we relate on this matter and come to some conclusion. I thank you. If there's anybody
Honorable members, I think we've been so unfair to the nominee, bringing her in here and then start this discussion. But please, before we can proceed to take the questions, I want to recommend that we suspend sitting for just about 10 minutes and we'll come. So let's first... No, please, Honorable, please.
Okay, 10 minutes.
10 minutes.
Chair, you keep saying something. No one here is being unfair to the judges. When you go to court, hold on. This idea, hold on. No. That we are being unfair to the nominee. Where from this one? That when I go to court and the court is doing their work, I should say that they are unfair to me because I've been sitting in the chamber for long. Is that the interpretation of how things work here? Is Parliament not another way of government? I will also recommend that the 10 minutes is too short. You are too ambitious about what you can achieve in 10 minutes.
I'm wondering because please, let's suspend for that 10 minutes and go to conclave in the inner conference room and then come back. We return.
So we meet where do you want us to be? The
inner conference room. No, it's just us. Nobody else. Please, yes, I think I'll discharge that. Not definitely. Please sit and let me. We are moving out. No, please don't decide.
to us.
Luck is every